and today we are here to present two different case scenarios about negligence and contract. So the first scenario is about negligence, and we've got three different issues. The first issue is that Michael was driving a car in a drunken state, which is not the ideal for a person. Because of the lack of self-control, accident may happen. And the second issue is Michael accepted to give a lift to Anna even though he was drunk. He should have denied to drop her home, but they both got seriously injured because he ran the vehicle into a tree. And the third issue here is that Anna knew he was drunk but still accepted the lift. She should have tried for more options. There are multiple laws related to drink driving that result in serious penalties. The Section 45 of Road Traffic Act 1961 states regarding careless driving. This means that the driving person must be careful, and the law also enables a person to be convicted in court and be penalized with maximum of 12 months imprisonment and fine of $500.
Hi, my name is Vinaya. Now I'm going to describe about the application of the first scenario, which is regarding about the Michael and Anna. As described in the scenario, it will be extremely hard to successfully sue Michael in negligence because she said a special relationship with him, because Anna was getting off on Michael's vehicle. She smelled him of alcohol. In spite of having detected presence of alcohol in Michael's body, it could be denied that Anna had to allow Michael to give her a lift. She could find another options, like she can call to friend to pick her up, or she can stay with friends home as well. If Anna is succeed in her actions, she will have to resort to unethical means. However, the means will not be entirely unethical, as she will be making use of the minute to fill of the case. She could invoke the Road Traffic Act 1961 Section 45 and Section 47, but the time have enough space to allow defendant to defend oneself. These rules tend to strike a balance between plaintiff and defendant by providing both parties equal chances of being heard in a civil court. Thank you.
Hi, my name is Sahil and I am going to present the second case scenario. But there are two issues that have occurred in the case of Brandon and Stephen. Brandon had mentioned in his letter to Stephen that he wishes to buy fabric from Stephen, and that Stephen must answer him back in a letter sent through the express post. Stephen instantly replies to the letter but ends up sending it via normal post. That took 3 more extra days and reached Brandon on 12th March. That should have reached on 9th March if sent through express courier. As a result, Stephen's replies reached to Brandon too late. The second issue revolves around Brandon's subsequent reply to Stephen. In the reply, Brandon had mentioned that to satisfy his fabric requirement, he had purchased the fabric from elsewhere. This has resulted in Stephen getting enraged and forced Stephen to claim breach of contract carried out by Brandon. So, talking about the regulations, a contract is said to be legally binding between 2 or more individual or business entities. This contract is legally present in the written form and may take form of a letter, a legal document. A contract becomes legally binding when offer made by a person is willingly accepted by another person. Secondly, Australian consumer law, also known as ACL, Section 21, states that unconscionable conduct is such conduct on the part of a business owner that proves harmful to a consumer. This relates to the discussion regarding providing goods or services to a consumer. It lays down certain factors, some of which are requirements of customer to abide by circumstances that are reasonably legitimate towards safeguarding of interests of supplier, use of any kind of undue tactics, influences, or pressure by the supplier, morality in suppliers' conduct with a consumer, evaluated in terms of similar situations of supplier conduct with similar consumers in the past. Thank you.
Hi, my name is Alfred. I'm going to present about the application and the conclusion about the case scenario 2. So there has been a case named as Administration of PNG vs. Lee, 1961. In the case, Lee has asked service from an officer of PNG to exterminate ticks that had infested Lee's, which is plaintiff cattle. But as they proved unsuccessful in their endeavor, Lee prosecuted them. At first, Lee seems to be successful, but when PNG appealed to the High Court, Lee lost the case due to the fact that there was no legal contract had been found between Lee and the PNG. So, continue to the next page. There has been a similar case that happened between Brandon and Stephen as well. So in the case, the letter was exchanged between Brandon and Stephen, which contained only Brandon's wish to purchase fabric from Stephen. Since Brandon was not trying to enter into contact with Stephen and therefore had no legal contract had been found, Stephen claimed that the contract has been breached, but it is unacceptable because the content in the letter is not reasonable enough to support the claim, and it only merely contains a wish of Brandon to purchase the fabric. Furthermore, under the section of 21 of Australian Consumer Law, this type of attitude under section 21 of Australian Consumer Law, this type of attitude that Stephen is called unconscionable conduct because he is trying to create an ethical pressure on Brandon. So let's move to the conclusion. So in the conclusion part, the consumer laws enforced by ACL are in favor of consumer, and it is odd because often traders attempt to either befool consumer or try to trap them unethically in legal cases. The case of Brandon being trapped by Stephen is illegal based on the fact that Brandon had not entered into any kind of contract with Stephen. The one of fabric had merely been mentioned by Brandon, and there have been no further discussion like the price of fabric or delivery address of Brandon. Therefore, it may be very easy for Brandon to defend against himself from Stephen's illogical claim of breach of contract by Brandon. Thank you very much.